Hello and welcome to this talk about reinstatement and re-engagement. My name is Declan O'Dempsey, and with my colleagues Olivia Faith Dobby and Adam Orringer from Cloisters Chambers, we're providing these talks to help people decide what remedies they want to seek from the tribunal at an early stage in the proceedings. How do you persuade the tribunal to make an order in your favour? It's a discretionary remedy, as we've already seen, but in relation to a reinstatement order, the tribunal has to consider whether you want it, whether it's practicable for the respondent to comply, and whether you caused or contributed to your own dismissal. Now, in respect of a re-engagement order, the factors are the same, but the tribunal has to consider what you want as regards the contents of the re-engaged job. And also remember that the question of practicability, is it practicable, will be asked of the respondent or the respondent's successor or associated employer. The tribunal can't make you ask for either order. If you want reinstatement as opposed to re-engagement, they'll consider your wishes as one factor, but it doesn't have to give you reinstatement. Remember, it's discretionary. In re-engagement, it has to consider your wishes concerning content. Now, suppose you've had a without prejudice offer of re-engagement from the employer. The employer cannot refer to this as part of the evidence as to why an order for re-engagement should not be made, because the courts have held that this is not unambiguous impropriety of the kind which would allow them to open up and scrutinise the without prejudice negotiations. Turning next to whether reinstatement or re-engagement is practicable, it's going to be considered, this question, whether it's practicable, is considered at the point of deciding whether the order should be made. It's also considered at a second stage if the respondent doesn't comply with the order. And it's only after deciding on both occasions that compliance is not practicable that a further compensation order is made. It's got to be considered as at the date when reinstatement or re-engagement would take effect. So that's not the date of the dismissal, and the date will vary depending on whether you're looking at compliance or the employer's failure to comply. And the question that the tribunal will ask is what is practicable, but in the circumstances of the employer's business at that time. So here are some examples of situations in which it's been held by the courts that it's not practicable to reinstate or re-engage. So where the industrial relations atmosphere of a factory was poisoned, it wasn't. Where the claimant showed that they distrusted or lacked confidence in the respondent and therefore would not be a satisfactory employee, it's not practicable. Suppose you've made allegations against people with whom you would work after the order, and it's impossible for you to work together with them. Well, it's not going to be practicable in that situation, but serious allegations made at one workplace wouldn't prevent you working at a different workplace. Suppose the job requires contact with the public, but the claimant can't be trusted with the public. Again, it's not practicable to reinstate or re-engage. Suppose the dismissal results from a changed policy, and if an order was made, that would require that new policy to be discarded. The tribunal is not going to make an order if you would be insufficiently employed, or if you're in a close personal working relationship at work with the employer. Finally, if there's been a genuine breakdown in trust and confidence between the employee and employer. Here's another good reason to ask for reinstatement or re-engagement early, which you'll find in section 116 of the Employment Rights Act 1996. Suppose your employer says, I can't reinstate or re-engage you because I already have a replacement. The Act says that that can't be a factor that the tribunal can take into account, unless the employer can show that it wasn't practicable for the employer to arrange for your work to be done without engaging a permanent replacement, or that the employer did engage a replacement after the lapse of a reasonable period of time without having heard from you that you want to have an order. And when the employer engaged a replacement, it wasn't reasonably practicable anymore for the employer to arrange for your work to be done except by a permanent replacement. So you can see there's a good reason why you should ask for reinstatement early, because that means that the employer may be able to get the work done by a temporary replacement. The other factor I mentioned was causing or contributing to your own dismissal. This is a factor that the tribunal must consider, but it's not an automatic ground for refusal. So it may still be practicable for the employer to comply with an order, and it may be appropriate for an order to be made, even if you've contributed to your own dismissal. But in the real world, the higher the degree of contributory fault, the less likely it is that a tribunal would have much sympathy with you, and the less likely, therefore, that an order will be made. Now, you will hear employers trying to resist your claim for reinstatement or re-engagement on the basis of the following type of argument. You would have been dismissed anyway if we had followed a fair procedure, and this is known as the polky argument as a result of the case in which the principle was first recognised in a slightly different field. Now, the tribunal, as a result of other case law, is not entitled to take into account the fact that it would have made this type of polky reduction to any monetary award known as the compensatory element, in order to reflect its opinion that if a fair procedure had been followed by the employer, you would have been dismissed in any event, or it was likely that you would have been dismissed in any event. The point is that that type of reduction is made under a different set of sections. Those sections deal with the amount that it's just and equitable that you should be awarded following a dismissal where no reinstatement or re-engagement is being ordered. In other words, that principle only applies to normal compensation, and it doesn't apply to these reinstatement and re-engagement orders. I mentioned earlier that there was an issue about non-compliance. Special rules apply. The Employment Tribunal considers whether it was practicable for the respondent to comply. If it was, and if you were reinstated or re-engaged, but the order was not fully complied with, so for example they allowed you to come back but they didn't give you the proper rate of pay, then the tribunal can award compensation to reflect the loss resulting from whatever non-compliance is identified. It's a different matter if there is no compliance at all. The tribunal will then calculate normal compensation and will award additional compensation. Now, additional compensation is an amount that you get above the ordinary unfair dismissal compensation. It's a minimum of 26 weeks' pay and a maximum of 52 weeks' pay. Now, that sounds wonderful, but there's a special definition of a week's pay. You'll need to get advice or look at the Employment Rights Act starting with section 220 to work out what the week's pay would be in your case, and we'll be doing some talks later on about this. However, It's capped at a figure which at the moment is around the mid 400s. I'm not giving you a precise figure because that changes from year to year. The other point to remember about it is that you calculate it using your gross pay. So if your gross pay is above the current cap, you don't include the amount that is above the cap. The award doesn't cover something which is fully compensated by normal compensation awards, and it's not intended simply to cover any additional loss suffered by the failure to comply with the order, but the tribunal will consider the employer's conduct. So suppose you've got a deliberate refusal to comply with the order. That will attract a payment at the top of the range, so nearer the 52 weeks mark. However, if the respondent genuinely believes that there's a good reason for refusal, that's a factor which is likely to reduce the award towards the 26-week mark, even if the tribunal does not accept that it was impracticable to refuse to reinstate. Finally, there's a maximum for the compensatory element of normal compensation. If the respondent refuses to reinstate or re-engage you, that maximum can be exceeded, but only to the extent that it's necessary to reflect the sums which the respondent needs to pay by way of back pay in order to comply with the order. So the sum total of the compensatory and additional awards have to reflect the back pay that would have been paid if the respondent had complied. In other words, the respondent can't be financially better off by refusing to comply. You can get further advice by going to the Cloisters website, www.cloisters.com, and following the links to instruct a barrister directly. Cloisters barristers can also help you to calculate the compensation you're likely to get from the tribunal, and they can do this before you engage with the mandatory conciliation with ACAS or before you engage in negotiation with your employer. If you're seeking re-engagement or reinstatement, do consider obtaining further professional advice. You can contact Cloisters at the website given above. Thanks very much.